make sure these are going.
Yeah, let me just make sure.
See if I'm pretty.
We had no problems yesterday, did we?
Everything's looking good, I think. This is going good, so.
All right,
Okay.
let's start. Judge Kane, today is May 21, 2019, and we're back again discussing your career.
Right.
And we were in the 1980s when we adjourned yesterday, and I thought I'd pick it up there. And I have a couple of questions about your relationships in your early judicial career with a couple of your colleagues.
Right.
Judge Richard MATSCH in particular. Could you describe that?
Well, yeah, that's the deepest one that I have. He was in the same law firm, Holm Robertson Olin, that I was, but he left before I arrived, and he went to the bankruptcy court at the behest of Judge Raj, and he also belonged to a club that I did at the time called the Cactus Club. It was a men's luncheon club, so I knew him as a former partner of the firm I was a partner in, and as a fellow that also went to the same club I did for lunch. And then when I came here, he was on the district court bench, and he was very helpful to me in getting started, went over the cases I had and suggested ways of handling different kinds of cases. And our friendship just developed over the years, and I would say that of all the judges that I've known over my lifetime, that he is my closest friend, and he is to this day.
And to this day, he still sits as a senior judge?
He's a senior judge. He sits and he presides over, we joke about it, he's in the Byron White building, cat-a-corner from us in the Iraj building, because traditionally, and this is typical of MATSCH, the district court held the courtroom on the north side of the building, on the first floor, or second floor rather. And when the 10th Circuit expanded and they wanted the space, MATSCH said absolutely not, that this was the district courtroom, and so he moved into it. And the post office had taken over the whole building, and then they had built a new post office building and moved out. The 10th Circuit wanted to expand, and so MATSCH went back into the courtroom that was originally presided over by Judge Hallett, the first federal district judge in the District of Colorado, and he's maintained it ever since. But since it's across the street, we south of here, we refer to it as the Southern District of Colorado.
Judge MATSCH was a fan of your judicial writing, was and is, and I recall a note that he penned to you where he decried his Prussian prose.
Yes.
Do you remember that note?
I do vividly. I still have it. He wrote a note. He said, I would trade a volume of my Prussian profundity for a page of your Irish verse, or Irish lyricism. Yeah.
Do you and did you exchange opinions with Judge MATSCH?
Oh yeah, all the time. And in fact, until until these damn computers came in, we used to circulate in writing our opinions. Each judge would write opinions and circulate them to the other judges. And we had judges' meetings in which we would discuss law. We discussed the opinions that each one of us had written. We discussed what the 10th Circuit was up to and what perhaps changes they had. in cases, and then we would discuss U.S. Supreme Court cases as well. That stopped with the computer, people thinking that they didn't need to meet and discuss, I guess. So during that time, we exchanged with all the judges. And then since that time, MATSCH and I are both somewhat Luddites when it comes to all these computers. And so we still exchange. But what happens basically is I will call him and say, can you send me a copy of your opinion? And if I think that I've written something that he might like, I send it over to him. And then occasionally, our law clerks will be on these machines and say, oh, MATSCH wrote an order, or his law clerk will say Kane wrote one, and we pull it up and read it and then contact one another. So he's made some extraordinary decisions, marvelous decisions over his career. And not all of them go noticed, because a lot of times the decisions that we judges think are important are not necessarily of economic or commercial importance, so they don't get the kind of public attention, but we think of them. For instance, he wrote an opinion in the last year or so about the terrible effects of solitary confinement on prisoners and prolonged solitary confinement. And he said that it was cruel and unusual punishment. Wrote a marvelous opinion. I think it's pending in front of the 10th Circuit now.
I heard you once say that you thought Judge MATSCH had really restored respect for the judicial process
Without a doubt.
in the Oklahoma City bombing trial.
Without a doubt.
Could you explain that?
Sure. I think you have to go back into the 1950s or 60s with Shepard versus Maxwell, and that they had cameras in the courtroom, and the Supreme Court finally in the Shepard v. Maxwell said that it had turned a trial into a circus. The courts basically shut down from press coverage at that point. And the courts, I'm trying to remember what it was exactly, maybe you can help me on this, but the courts had come out with some decisions that the public was really dead set against. And oh, I know what it was, now I remember. It was the football player, O.J. Simpson. And that was another kind of Shepard versus Maxwell circus, with the press dominating the courtroom, and the lawyers and the judge all preening in front of the cameras and trying the case to the press rather than doing what they were supposed to be doing. And O.J. was acquitted, and there was a lot of public discussion and complaints about what a fiasco that was. A lot of columnists were talking about the court system cannot exist with today's communications and so forth. And so then the Oklahoma City bombing occurred, and the case was started in Oklahoma City, and the grand jury issued its indictment. And the feeling there, understandably, was so strong that they wanted to have a change of venue to some other place to try the case. And because each of the judges was totally personally affected by the explosion and destruction of the buildings and the death of many of their people they knew, the Chief Judge rather of the 10th Circuit was Stephanie Seymour, who was likewise from Oklahoma, and she appointed Judge MATSCH to be the judge on that case. And he went to Oklahoma and he looked at things and he considered the motions and so forth, and he decided he would try the case here in Colorado. And so he did. And he handled it with no cameras in the courtroom and no public statements by himself, but he had, in effect, the clerk of the court was Jim Manspeaker's at the time. Jim Manspeaker was the clerk of the court, but he effectively functioned throughout the Oklahoma City bombing case as the court's press agent, and he coordinated the reporting, and it had international coverage. But the press is very interesting to see. They would observe it, and so did the public, with the dignity that Judge Mage handled the case, and the stern yet compassionate control that he had over the courtroom was unquestionably one of the finest demonstrations of what a judge should do under the most arduous of circumstances. And they had the trial, and then McVeigh was convicted, and then they had the sentencing. And among other things, what he did, somewhat unusual, but because the people in Oklahoma City were deeply interested in what was happening, he had a large room, auditorium, perhaps courtroom, I'm not sure, but he had this facility there to allow the citizens of Oklahoma City to look and watch the trial proceedings. And so there was a closed circuit television, and it televised in the courtroom here in Colorado and sent it down to Oklahoma City so that these people could watch it. And then Judge Mage had a friend of his, of long standing, a friend of mine as well, who was a state district judge, and he had retired. And so Judge Mage asked him to go down to Oklahoma City and preside over that auditorium, and he did go down there and preside. Now, the case is unique in American jurisprudence for at least one reason, and that is that Judge Mage wouldn't, according to law, he wouldn't allow any cameras in the courtroom, or television cameras or otherwise. And Congress passed a statute while the case was pending, authorizing the televising of that case from Denver down to Oklahoma City. So Judge Mage was the only trial judge in the history of American jurisprudence who was reversed during the course of a trial by an act of Congress. But the pressure was that great that it happened. So then he had the sentencing, and the courtroom was specially designed. He did a wonderful job of protecting the jurors who were concerned, as everyone was, with the safety of the lawyers and the jury in this courthouse, because the other one had been blown up. And Judge Mage had the courtroom designed so that people could sit in the spectator section, but they would not be able to see the jurors. And the jurors could see everything in the courtroom, but not the spectator section. And then, of course, there was extra security measures that were taken, and he supervised all that, made sure that everything was safe, without going into the vaudevillian nature that some courts have of showing the defendant in manacles or in an orange jumpsuit. He didn't do any of that, and the guards kept their distance so that the case was tried without being under the point of a gun or that sort of thing. The other thing that he did was to have security for the jury. The jury would meet at different locations throughout Denver, rather than have them all be confined in a hotel and marched and sequestered, as the expression is. They could go home at night, but they would come into the courthouse through a private entrance into the courtroom and the jury room adjoining it, and then at night they would all get back in, and the marshals would take them And because they were fearful of being followed by somebody, they would change the location each night of where they would meet. So they'd meet at a shopping center out in East Denver, then they'd meet in a shopping center in West Denver, in a parking lot. And they would park their cars to get in and then come in via bus to avoid any sort of contact with anyone, the press, and mainly for their security. Because we were all concerned. This McVeigh had blown up an entire building. Lots of people were killed, and there were fellow travelers of his who had made similar threats. So there was a lot of pressure. But he handled that whole thing with grace and with dignity, and my favorite word for him is with rectitude. When it came to the sentencing, and the jury returned a verdict of death, which is perfectly understandable, but he was asked afterwards, when he pronounced the death sentence, and it's the only time he ever did or had to, and he was asked for what was it like to be a judge and pronounce a death sentence, and his answer, typical Mage, very brief, he said, and this is an exact quote, he said, "It was stark." And that was all he could say about it.
I recall McVeigh, I was present at the sentencing. I recall McVeigh, when Judge Mage sentenced him to death, stood ramrod straight and nodded towards him with great respect. It was extraordinary.
I'm sure that's the case, that McVeigh, I can't remember where I learned that, but I learned that he had great respect for the way that Judge Mage conducted the trial and the way he was treated. There was some difficulty at the very beginning of the case with, I think, one of the lawyers that had come in to represent McVeigh was trying to become world famous at the expense of the trial, and I don't remember what his name was, but I remember that Mage called the attorneys into his chambers and said, "This is how we're going to try this case," and that was an end to the press statements.
His name was Stephen Jones.
Okay. All right.
When you...
I was being gracious by not mentioning it.
I outed him. When you were first sworn in as a district judge, Fred Winter was the chief judge at that time. What was your relationship with him?
We had a very stormy beginning. It's kind of a fun story, really, because we ended up as very, very close friends. But I think I've never been politically active since the last time I was politically active was in the Kennedy campaign in 1959, when I was the Colorado State Chairman of Students for Kennedy. And after that, I just got into law, and I never really became active in partisan politics. But my father was a Democrat, as well as my mother, as well as everybody else in my family, and I registered as a Democrat and voted that way. But I was not a political junkie and hanger-on or anything like that. So when former Congressman Brotzman was blue-slipped, and President Ford had nominated him, Senator, I think it was Senator Gordon Allett, who had been advocating for Brotzman's appointment, who was also a Republican. And Fred Winter had been a lifelong Republican, and he had been appointed by Richard Nixon to the bench. So when Jimmy Carter came in and I was appointed, I can understand why, but people thought that, well, here's a Democrat, and this is politics, and they're putting in a Democrat. I'm not sure of this, but frankly, I don't know if that Merit Selection Commission even knew whether I was a Democrat or not. I just don't know. I was never brought up. But I didn't have any political connections, was the case. But that's not what Judge Winter assumed when I was appointed. So he made some kind of comment after I was appointed, well, we'll just see if we can deal with one of these liberal Democrats coming over here, something to that effect. So when I first got here, he wasn't unfair, but he was very strict and very distant about me. And I went in to see him, and he said, well, these are your cases, and you handle them as best you can, sort of thing. And he did offer me at the very first meeting a piece of advice that he said, you're accustomed to practicing in state courts, and they have the same rules, but they don't use them, and we do. And he said, summary judgment is a big thing over here in federal court. It's not in the state court. You're going to have to get used to that. So anyway, I had my chambers, and the clerk treated me well, and I didn't have much other contact with Winter. I had appeared in front of him, and he'd always treated me very well. I didn't have any animosity, but it was somewhat strained when I got here. And that was in January. So things went along, and in March, St. Patrick's Day came up, and I sent green carnations to all of the clerk's office employees and to my staff and the judges' staffs, and said that I would not be available. It was on a Friday that year, and I said I will not be available on March 17th. And he called me, and or his secretary did, and said, Winter wants to see you now. And so I went in to see him, and he had his commission on the wall. It was, as all the federal judges get a commission that's signed by the president. And so I came in, and he said, who do you think you are? You can't declare a holiday. Holidays are declared by Congress. This court isn't open for everybody but the Irish. And he really was nailing me for this. And I just had enough of his guff. So I pointed to his certificate, and I said, you see that certificate on the wall? And he said, yes, what of it? And I said, well, I have exactly the same thing, only mine isn't signed by a felon. And he looked at me, gritted his teeth, and then all of a sudden he started to smile, and then he laughed, and he said, you're going to do okay. And that was the change. As soon as I had stood up to this, that was it. And then we became very close friends. By the time he retired, the poor guy, he was living in Grand Junction where his daughter lived, and his wife had passed away. He'd had a very, very close, devoted relationship with his wife, and it took a lot out of him when she passed away. And he was losing his eyesight, and he was hearing. So I'd go over to visit with him at that time and spend a little bit of time with him whenever I could. And we have a courthouse over there. He was instrumental in having it remodeled and doing his best to get federal cases heard in Grand Junction. If they occurred on the western slope, he wanted them heard in Grand Junction. So I had cases that I was able to have over there with local counsel. And so when I could, I'd go over, and I'd always spend the night and visit with him. And by the time he passed away, we were very close friends. I'll tell you one funny story about Judge Winter that I didn't have anything to do with, but it was said of him that he was the best trial lawyer in the state of Colorado ever had, and he never changed when he became a judge. He didn't have quintessential judicial temperament. He would seize on the issues immediately, and that's the way things went with him. But he also exercised, and he was in his 70s. He was a slow jogger, but he would jog. So he was over in Grand Junction, and the clerk, Jim Manspeaker, was with him. And Winter was notorious for getting up at 4 in the morning and exercising, and then being on in his chambers by 5:30 every morning. And if he didn't like a lawyer, he set hearings at 5:30 for them. So, he was in Grand Junction, and he was staying in a hotel, and at about 4:30 in the morning, he gets up and has his sweatpants and sweatshirt on and his sneakers, and he's out jogging. And a Grand Junction policeman on patrol pulls over and sees this guy in his 70s sort of jogging along the side of the road, and he pulls over and shines a light on him, and of course Winter didn't have any identification because he was in his exercise clothes. And the police officer, so the story goes, said, "Who are you and what do you think you're doing?" And he said, "Well, I'm Fred Winter, and I'm a United States District Judge, and I'm exercising before I go to court, but I will be in the federal court here in about 1 hour." And the guy said, "Sure, you're a federal judge." He says, "And I'm Elliot Ness." And he arrested him, and he took him to the police station, and Winter said, "Do I get a phone call?" And he said, "Yes." So he called the hotel for Manspeaker and said, "Go get my wallet and come down here." So Manspeaker had to go to the police station, and I guess that police officer was just totally embarrassed by it. And as Winter was leaving, he said, "Mr. Ness, thank you very much." But that was Fred.
I'm still in the first decade of your time on the bench, and in the middle of the 1980s, 1984, I think, the United States Congress signed and passed, and the President signed a bill which created the United States Sentencing Commission and Guidelines.
The Sentence Reform Act.
Yes. And you have had your disagreements with that statute
From the beginning.
From the beginning, and you've written on the subject many times. When the guidelines first came out, they weren't immediately effective. Do you recall the first time you had to deal with them and what you did about it?
The law was enacted in 1984, and then they had to construct something that Washington hardly needs, but they did, another bureaucracy with the formation of the Sentencing Commission. And then they formulated these, they call them mandatory guidelines, which if you have any respect for language at all, you recognize that to be an oxymoron. There's no such, you can't have a mandatory guideline, but that's what they were called. And they were voluminous. Among other things, the Sentencing Commission and its staff claimed that they had reviewed 10,000 sentences throughout the federal courts of the United States, and they came out with these arithmetic guidelines that scored certain points for certain kinds of offenses, and then other arithmetic calculations. They're not calculations, they're just arbitrary numbers attached to characteristics of the individual. So that you had two axes going. One was the nature of the offense, and the other was the nature of the defendant. And they would put these together on a graph and total up the points, and that would be the sentence. And there was a provision that the sentencing judge could vary, I think, as best I recall, a maximum of 15%, which meant 7.5% one way and 7.5% the other way. That you, if the sentence was, as an example, 10 years, you could go slightly below or slightly above, but it was mandatory. And I had a case very involved with, as I remember, there were 18 defendants, and they were all members of the same extended family, and they were smuggling heroin into the Colorado State Prison, using their young daughters as vehicles to transport the drugs into the prison and to transfer them from these little young ladies and little girls to the prisoners who they were visiting. And it was disgusting the way they were doing it, but nevertheless, that's how they were getting the drugs in. And the family were notorious in criminal, in the criminal environment with police and so on. Everyone knew this family, and almost all the men were either in prison or were on parole or had been there. And it was a very tough case. I had, among other things, the alleged leader of the family who tried to disrupt the trial, and I had to put him into a room with a television camera away from the trial because he would not conduct himself appropriately. And at the end of that particular day, his lawyer came to me and said, so-and-so wants to know how long he has to stay there. And I said, I don't know, I'm appointed for life. And so the next day, he conveyed to his lawyer that he was ready to behave, and he did after that. So he was through the trial. But it was the first case that I had where these mandatory guidelines were to apply, and I wrote it. I refused to do it, and I wrote an opinion that said that these were clearly a violation of Article 3 of the Constitution of the United States, and a violation of judicial independence, attempting to have a committee or a commission substitute its judgment for that of a judge who had been appointed by the president with the advice and consent of the Senate in accordance with Article 3. And this was a jurisdictional matter, and I thought, still do, deeply a matter of principle. So I wrote this opinion declaring it unconstitutional. Judge Matsch, at the same time, wrote an opinion declaring it unconstitutional as well. And Judge Kerrigan, who was on our bench, wrote a similar opinion. And there were maybe approximately 30 opinions around the country by district judges that agreed with this position that the Sentencing Reform Act and the mandatory, not the entire Reform Act, but that the mandatory guidelines were unconstitutional. We had a judge here, Sherman Feinsilver, who wrote an opinion that said it was constitutional. And frankly, it wasn't a very good opinion, but it wasn't well reasoned at all. At any rate, the Department of Justice did not appeal any of these decisions around the country except one. They took the case of Mistretta versus the United States, and that had to be one of the most casual rulings by a district judge declaring something unconstitutional. I mean, it was just sort of the judge off the cuff saying, well, it's unconstitutional. So the Justice Department picked that very weak read and appealed it directly to the Supreme Court. And the Supreme Court held that the mandatory guidelines were constitutional. But the government did not appeal any of these other sentences. So my last sentence was one using the established law under Section 3553 with the criteria that are used there. And I made sentences for all these different defendants, ranging from probation to very heavy sentences. And I was just thoroughly disgusted with the idea that they would reduce the judicial function to filling out a form. And I do remember that one of the assistant U.S. attorneys said, well, this is the statute, and you have to go along with this. And I said, well, why should I? I said, it's not a judicial act. Why don't you have the clerk of the court impose sentence, since all he has to do is fill out the forms? So at any rate, that happened, and I'm told there are no coincidences in life, but coincidentally, I was being treated for a chronic disorder called obstructive sleep apnea.
This is 1988 when Estrada was decided?
1988. And I started to have what are called in the medical trade microsleeps. They're really blackouts, but they last for maybe 5 seconds up to 20 seconds. And what happens is that when obstructive sleep apnea, and they still to this day don't know the cause of it, but you go to sleep and then you don't get the REM stage of sleep. You just barely are asleep, almost awake. And when they measure this with gadgets they plug you into on the brain and so forth in sleep studies, and you wake up as many as 700 times a night. So you don't get the REM stage, and so the result is that you can have these micro sleeps. And at that time, the medical understanding of obstructive sleep apnea was just in the beginning stages. And in fact, the disorder was frequently misdiagnosed as being, oh gosh, I'm trying to think of the name of it. It's a Dickens character who falls asleep all the time, begins with a P. I can't. At any rate, that's they called it that syndrome, and then sometimes it was referred to as narcolepsy. And so I went to a friend of mine who was a psychiatrist and ran a clinic by the name of Henry Fry, and I told him what my problem was. And he said that when he had done his residency at the University of Colorado, there had been another resident there who had gone to Stanford and had become an expert in sleep disturbance medicine. And so he said, let's do some tests here and send them to him. So I went to a clinic and overnight had a sleep study, and we mailed it to this is pre-computer. You're right at the first of it, so we didn't email, we sent it snail mail. But anyway, it got to him, and I was, I'd been invited to University of California at Berkeley to give a talk at the law school. And so I had gone out to San Francisco, and my plan was to, once I gave my talk, was to go down to Palo Alto and see this doctor. So and I was in the hotel in San Francisco, and I called him and said, well, I'm ready, do you have time to see me and go over this? And he said, don't come here. He said, we're doing research, and he said, I've got a lot of research assistants, and he says, they're dealing with chimpanzees. He said, if you come here, he said, you're just going to be put into a study, and you may be treated or you may not be, depending, a blind study and all that. And he said, but we have graduates who are at the National Jewish Hospital in Denver who are treating physicians, and they're expert in this field. Go back to Denver, and he said, you do have obstructive sleep apnea. So I went, came back to Denver, and I had the sleep studies, and that was a time before they had these continuous positive air pressure machines that CPAP machines are called, and it's a machine that fastens onto your nose or your mouth, and then it keeps the air passages open so that you can actually get the kind of REM stage sleep you need. And since that time to the very present, I use one of these machines. In fact, I have a portable one. If I travel at all, I take it. It's battery operated. But at that time, the CPAP machine was built by hand by somebody in the lab at National Jewish, and it was the comparison that was made is it was a Model T compared to a Ferrari, today's kind of CPAP machine. But in those days, you try to go to sleep and you'd hear this thing sliding back and forth, click, clack, click, clack. But at any rate, I got that machine, and I came back to the bench, but I had taken, in April, I'd gone to see our chief judge of the circuit, and I said, I can't preside at trials. I'm having blackouts, micro sleeps, and so he talked to the doctors about that, and I gave him written reports on it, and so I took senior status under medical disability, and I was gone for a year.
So at the age of 51, you took senior status?
I did, and I've been a senior judge since then. But I was, it took a full year to get to the point where I was no longer having these micro sleeps. So during that time, I had a law clerk from Ireland, and he said, well, why don't you come over here? He said, Trinity College would like to have you give a few lectures. So I did go over to Ireland, and I was, in addition to doing research and making a few lectures at Trinity College, I also met some members of the medical faculty, and they knew a lot about apnea, and they were instrumental in helping me. So when I came back, I felt ready to judge again, but I was cautious, and so was Chief Judge Holloway. So I started out just doing non-trials, doing appeals from administrative agencies. So I handled a lot of Social Security appeals and a lot of administrative agency appeals. And at one point, when I was doing all these appeals, I was designated by the 10th Circuit to sit there on an appeal, and I wrote an opinion on administrative law, which to this day is considered one of the key cases in that area as to what a district judge has to do in handling an appeal. And the reason why it has an importance is not because of me, but because district courts are essentially trial courts with juries and finding facts. That's what the essence of the trial court is. But Congress has given us jurisdiction as well over appeals from some administrative agencies. And the appeal is not done with a trial. It's done by having briefs, oral argument if you want them, and reading and studying the record. And how that's done is set by certain legal standards. And so trial judges don't identify themselves as being appellate judges. And the natural tendency with when a district judge gets an appeal is to put it on the back burner and say, I've got to be in court. There are lawyers there, there's juries there, I've got all of these people I have to work with. I'll get to that appeal later when I have some quiet time. Well, quiet time is rare. So what that means is that these cases get stuck and sometimes backlogged. And so I was trying to come out with this case on the 10th Circuit and with the work I was doing here at the district court level to do things that would improve the speed and the efficiency of district judges handling these administrative appeals. And it became sort of an opinion of this is what you must do and how you do it. Because the judges were all over the map on it before, and the one that I happened to have in that case was really, really confused.
That case was called Olin House, Olenhouse.
Yes. Yeah.
And as I recall, it involved some farm subsidies.
It did. It did. It was the Department of Agriculture was involved, and these farmers had lost their crops due to, as I remember it, it's been so long, but due to storms and rain rather than drought. But they had lost their crops, and so they had gone before the Agricultural Adjustment Board to get compensation, and it was denied them. So they appealed, and they appealed to the district court in Kansas, and the trial judge there just did things that are hard to imagine, really. But they demonstrated no familiarity with an appellate process at all. He treated them as though they were summary judgment motions. And so he had the government file what he invented as and called a motion to affirm, and then the appellants had to file a response to the motion to affirm, and then the government filed a reply. Well, that shifts the entire nature of it, because the appellant's supposed to have the right to file the opening brief and identify the issues, and then the appellee, the government, to file a response, and then the appellant file a reply. And this just totally reversed that process. And then he did not look at the record. He just looked at the motion and did not examine the record. And then he had the government, almost in a cavalier fashion, says to them, well, you draw up the findings. I'm affirming the action. And so it went, the action of the agency. So it went from there to the 10th Circuit Court of Appeals, and I happened to be sitting with Judge Logan, was presiding, and he was from Kansas. And the way that appeals work is that the judge, who is the presiding judge, after the oral argument, he decides who's going to write the opinion. And if you have 3 judges, do all 3 agree, or at least you need at least 2? And they inevitably, in my experience, they take the most junior judge speaks first. And if you're a district judge, you're more junior than the junior appellate judge. You're just sitting there by pure grace. And so he came in and he said something to the effect of, well, he said, this happened in Kansas, and he said, I know too many of these people. I know the judge, and I know the lawyers and all that. And he said, I don't want to deal with this. And he said, it seemed pretty cut and dried. And he turned to me and he said, would you take this? And I said, sure. And so we were all in agreement that there should be a reversal, but Judge Logan, when I turned in my draft, he said, I never imagined it would be this much work. He said, I thought this was just one of these order and judgment things where we reverse because he didn't make the findings himself and that'd be the end of it. And I said, that was just the beginning. And so he went along with it, and so did the other judge. And Olin House became law. The government petitioned for an en banc review with the 10th Circuit, and that was denied. So Olin House became precedent by the Court of Appeals, even though it was written by a mere district judge.
And it's now today the standard of review for administrative appeals?
It is cited frequently, not only in the 10th Circuit but elsewhere. And I am told, I don't know this for a fact, but I'm told that when somebody's appointed to the district court bench, they provide the Federal Judicial Center an orientation program, a judge's program. It is colloquially referred to as going to baby judge school. And I'm told that they use that case in their materials when training new judges how to handle appeals. So yeah, I'm very proud of that. And I had an absolutely splendid law clerk working on it with me.
In the mid-1990s, after you became a senior judge and you were doing one of these administrative appeals of federal agency actions, you adjudicated and decided a very important and controversial case called Saum, S-A-U-M, versus Widnall, W-I-D-N-A-L-L. Sheila Widnall was the Secretary of the Air Force.
That's right.
Could you walk us through that case and its importance?
Yes, I can. I would begin by saying that I think that the plaintiff's lawyer in that case, whose name is Doris Besikoff, and I haven't seen her since then as a lawyer, but she was unquestionably one of the best lawyers I've ever met in my life. Her representation in that case. And if people think that lawyers don't make a difference, they should look at that case, because her genius and her dedication were present throughout. And I think I contributed something to it, but I think she was inspiring, the way she handled it. When the military is involved in a case, there are various doctrines, the Freris doctrine being the primary one, that says that the civilian courts should not interfere, that it's repeated time and time again from certainly from the time of the Civil War all the way to the present, that civilian courts don't have the wherewithal or the knowledge to handle review of military decisions. So when the military finds itself in a civilian court like the U.S. District Court, it's very rare, and frequently the military comes in with their military lawyers and they move to dismiss, and I'd say more often than not these cases are dismissed, but this one wasn't, and it came very close. For one thing, you cannot get a money judgment against the military in a U.S. District Court. So the Federal Tort Claims Act doesn't really apply to the military. But you can get, under certain circumstances, equitable relief. And the distinction is that an action at law results in money damages, and an equitable judgment is one that compels somebody to either do or not do certain things. So it regulates behavior and performance rather than assessing damages and paying money. And so it's possible to issue an injunction involving the military. And Doris Besikoff recognized that from the get-go. So she came in not asking for money damages, but for equitable relief in a theory of unjust enrichment, which in the long run amounts to money, but that's...
What were the extraordinary facts of that case?
Okay, these are the facts of the case. Elizabeth Saum was a high school girl in, I believe, Toledo, Ohio, but she was in Ohio. And she was in a fairly large Catholic family, going to a Catholic school, and she was a highly talented diver, and she was on the school diving team, and she won state contests in diving, and she also was, I think, in some kind of national high school tournaments that she was a medal winner. So the recruiting and appointment period for the military academies had stopped. It was over with, but the people in the athletic department at the Air Force Academy were aware of Elizabeth Saum. They somehow or other discovered this, and this was at a time when women were co-educational cadets. The admission of women into the military academy was very, very new at that time. So they were trying to build up the women's athletic department, and they sent these two people from their athletic department. I frankly don't recall whether they were military officers or civilian employees, but whatever they were, they went to Ohio, and they met with Elizabeth, who was a tiny thing. She barely made the minimum height requirement for the Air Force Academy. I think like 5'1" or 5'2", something like that. And she weighed 100 pounds. And so they talked with her and her family, and basically she said, I don't want to become a pilot or anything. I want to go to med school. And they told her, well, if you go to the Air Force Academy and you complete your studies there, then the Air Force will send you to medical school, and that'll be paid for. And then you only have to do so many years as a medical officer in payment for having had all this done. And while you're an undergraduate, a cadet, you get room, board, tuition, fees, books, and an allowance. So she had already been admitted to a different school. I don't recall which one. I think it was Davidson, but whatever it was. She withdrew her application and she went to the Air Force Academy. And when she went there, they had, they didn't call it hazing, but they take all the new cadets and put them through miserable conditions. And part of what they were doing at that time was simulating a cadet being an Air Force officer who is captured by an enemy and being tortured. And they used her. She went through all other kinds of hazing and calling. She was a very pretty young girl, and they called her the prom queen, and the other cadets would say, you're too little, you're just here to get a man, you're too pretty. And they were constantly putting her down. But then they did some truly atrocious things to her and simulated rape, and they videotaped it and showed it to the entire cadet wing. And she went through severe trauma, and by the end of, I think it was the first year, she couldn't eat, and she went down to 85 pounds, and so she was furloughed for medical reasons because she didn't meet the minimum weight requirement. And she got back home and she didn't want to go back to the Air Force Academy, and eventually she found this lawyer, Doris Besikoff, and they filed suit. And her life had essentially been ruined by this action. So the Air Force moved to dismiss, and I denied that. And then it developed in the course of the trial, or not the trial, but in the pre-trial proceedings, that Elizabeth and her mother had gone to Washington, and they had met personally with the Secretary of the Air Force, Sheila Widnall. It was Dr. Sheila Widnall. So I don't know what her PhD was in, but she was the Secretary of the Air Force. And they talked with her for a while, and then they went back to Ohio, and then they filed suit. And I soon discovered that Sheila Widnall was a personal witness, and Doris Besikoff wanted to take her deposition. The Air Force refused, said she wouldn't be there, and that this was just harassing, and that the secretary was too important to do anything. And I said, under normal circumstances, just because she's the secretary, I would not permit her deposition. But she's a witness, a percipient witness is the term we use in law. She was there and she had conversations, and she can be deposed. And so they said, well, she won't come out here. I said, she doesn't have to. We'll take the deposition there and make it as convenient as possible. And then these lawyers came back and said, well, she won't do it at the Pentagon. And I said, that's all right. I said, I'll have a U.S. Marshal arrest her and hold her in contempt of court, and she can take the deposition in the jail in Washington. Well, they heard that, and they decided maybe she should have her deposition taken at the Pentagon. And so Doris Besikoff went back there, took her deposition, and that was the end of that recalcitrance, as you will, by the secretary. But we came back here, and we started to have hearings. There was a motion to dismiss, and I wrote an opinion denying that. And in one of the hearings, this overly emotional major in the Air Force JAG stood up, and it was right during Bosnia, that Bosnia campaign, and he said, these people want you to determine the conduct of the first Air Force pilot who was shot down over Bosnia and how he should respond to torture. And that's what this program is for. And I recall vividly, I just looked at him and I said, I mean, first of all, we knew this young lady was heading towards medicine, not towards being a pilot. But I also knew that Air Force graduates all graduate as navigators. They have to go into pilot training after the Air Force Academy. And they have an engineering degree, but it's in the essence is navigation. So I just turned to him and I said, how many graduates in her class are combat pilots? How many of them are you training for combat pilots? What is the percentage of your graduates who become combat pilots? And he said, well, I don't have that information available. I said, well, it isn't all of them, and she wasn't one of them. And so he sat down and I wrote the opinion, and I believe this to be the case. I think I mentioned it in the opinion. I think I did, just a footnote, something like that. But I said, you know, this was illegal recruiting according to the NCAA, what they did after she'd already committed to a school, and the recruiting period for the Air Force Academy was over and done with, and they went out and cajoled her into coming in. So I said, it's not only what the court does, but I said the NCAA may want to take a look at this as well. Well, I think that's what settled the case.
But the case ultimately settled?
It settled fast, and she got her records cleared, and she got a certain sum of money. I don't even know what it was.
Did she get to medical school?
No, she didn't, as a matter of fact. I found out later, a note. I used to get a Christmas card almost every year from Doris Besikoff. She had moved to San Diego, and in one of them she said that Elizabeth had graduated from college, but she decided not to go to medical school, and she was married and had a baby. So that was the end of that. But she was set for med school at the time.
But when you returned in 1989 and were on senior status, but you returned to the bench, my understanding is that by agreement with Judge Holloway of the 10th Circuit, you were only going to take civil matters and administrative matters.
Just appeals at that time.
Just appeals.
Right.
You eventually started taking very complicated civil matters.
Yeah, that was, there are two aspects to that. One is that as a senior judge, you have the right to decline to take a case that's assigned. You don't get to pick which cases you're going to have, but if one's assigned and you don't want it, you can just exercise the senior judge prerogative and not take it. So when I came back, I would not handle criminal cases, and the reason I wouldn't was because I thought that it was unconstitutional, that it was a violation of my oath to sentence according to guidelines, which were mandatory. So as long as they were mandatory, I never handled another criminal case. When the Supreme Court of the United States decided, there were a series of cases, but the main one was Booker versus Washington, and when that case came out, and Judge Alito said that the guidelines were advisory, then I felt that I could consider the guidelines, but I would still be the one making the decision in accordance with the requirements of Article 3. So I went back on the draw. But in the meantime, it was about 10 years or so, I first started with the appeals, and I left in April of '88, and I came back in June of '89, and by about, I think, probably December, I started handling a few jury trials, very short, brief ones, 1 or 2 day jury trials, and to make sure that I could do it and I wasn't having blackouts anymore. And I did that, and then I felt ready after probably February of 1990 it would have been, and I just went back on a full civil draw, but not a criminal draw. And I met with, I think it was MATSCH. If it wasn't, I think it was MATSCH was chief judge at the time. If not him, then it was Lou Babcock. But I looked at the situation, and the problem with all kinds of statistics is that they make no distinction between individual units. So the old expression is that I learned was well, when I was in India, it was a fellow said, well, I have a friend and my friend has an elephant, and they both drowned in a river having an average depth of 5 inches. And so if you look at that, what happens with a case is that it could be a student loan foreclosure, which takes about 5 minutes. It's just the promissory note's there, the payments haven't been made, end of case. It'll take more than 5 minutes, but not much. And that's one case. But you can have a toxic tort case that will take 20 years, a class action, and that counts as one case. So what happens with active judges who have to take whatever is assigned to them is that they can handle cases, and they get one of these monster cases and it destroys their ability to handle the others because of the volume of cases they have. So I looked at that, and I said, my experience has been on these administrative appeals that I've been taking those from other judges who've never got around to them. And I said, I'm ready to go into regular trials, and rather than just be on the draw, why don't I take cases that are reassigned by the chief judge that are highly complex, that take up more time? So I would be on a reduced caseload, but the cases I had would be highly complicated ones, and that would free up the active judges from having to have their dockets vandalized or restored, destroyed by these real heavy cases. And one of them, as an example that came along a little bit later, was a habeas corpus proceeding involving the defendant's name was Dunlap.
Nathan Dunlap.
Nathan Dunlap, and he had murdered 4 people and severely wounded another, and he was tried in the state court. And the state court, he was convicted and sentenced to death, and he went before the Colorado Supreme Court and the Colorado Court of Appeals, and the case went on and on and on. And each time they would petition the Supreme Court of the United States for certiorari review, and it was always denied. But they finally exhausted all of these proceedings, and lawyers came over to federal court with it's called 2254, but it's essentially habeas corpus, saying that he had been denied competent counsel in the state court, so they wanted the death penalty set aside. And that required a judge to look at, I think, well over 10,000 pages of transcripts and judicial opinions that had been done over this lengthy period of time. And it was assigned to one of our newest judges, and that judge came to me and said, this is one would you take it? It's just, I will spend all year long on nothing but this. And so I did. And I remember I did that particular case almost to the exclusion of all the other work I did for reading through January, or through June, July, and August, and came out with an opinion in that September upholding the competency of counsel and therefore the death penalty. And then it went on with more appeals and things like that. But it was a monster case, and for more reasons than one.
Was that difficult decision for you because you've dealt with and have questions about the death penalty in the past?
No, it really wasn't. What I was concerned with was the issue was whether the lawyer had been competent or not. And so I had to examine each and every decision that had been made by the lawyer, two lawyers in fact, and the law under Strickland versus Washington is very clear that there's a distinction between strategic decisions and tactical ones. And a lawyer can be incompetent for making tactical errors, but not for strategic errors. So you have to do a very heavy analysis to see what the lawyers were doing. I didn't, I hadn't, sure, I had private feelings about the death penalty, and I still do. And I think when I had that case, it was already 20 years old, and one of my objections to the death penalty is that it's never done on time. I mean, to have somebody on death row for 20 years, to me, is a recognition that the system does not function the way it should. The system doesn't function the way it should because there's no evidence at all that the imposition of the death penalty operates as a deterrent. Murder rates in comparable states, one having the death penalty and the other not having it, there's no difference in the murder rates. So it does not do what it assertedly is purposed for, of operating as a deterrent, and it doesn't operate as a matter of justice for the victims, the survivors. This case had 3 of the victims were teenagers working in this restaurant, and their parents lost their children, 17 and 18-year-old kids working part-time in a restaurant. And I do remember, I never met these people, but I remember when I came out with my decision, it was covered by the local press, and there was the father of one of these young ladies, the 17-year-old girl, and he said they didn't care what happened. It was too long. They've been living with it every day, and whether he's sentenced to life imprisonment or death meant nothing to them at that point.
Your decision came out in 2006. We're now in 2019. Mr. Dunlap is still on death row, but he hasn't been executed.
That's right. So apparently there's a contradiction in the public view of the death penalty. On the one hand, politicians all say they're in favor of law and order and they want the death penalty, and the killers should be punished accordingly. But when push comes to shove and they have to actually do that, they don't want to do it.
Another career case that came your way right after coming back on senior status, I think in 1989, is a case involving Rocky Flats. It's called Cook versus Rockwell International. It was filed in 1989, and it was finally resolved in this court in 2018, almost 29 years later. Right. Can you describe?
Sure.
I would say, I wouldn't call it the arc of that case, but the slog of that case.
Yeah, that case was handled by 3 other judges before I got to it. And the reason I got to it was what I have just previously explained about a very complex case takes all of one's time to do. And the other judges had just said, you know, you want a complex case? We'll give you one. Cook v. Rockwell was a class action, and it started out before I got there to the case. I got there, I mean, before it came to my court. But I always think of before I got there because it's a universe of its own. But before Cook v. Rockwell was assigned to me. The claims were for a class of people of about 30,000 or 20,000 who had been exposed to plutonium because of the negligent way in which plutonium was being handled at the Rocky Flats nuclear facility. They were making plutonium triggers for nuclear weapons, and there had been, they were storing the refuse material, it was radioactive, in boxes out on the open plain. And there had been rainstorms and other things causing rodents, etc., that a lot of this refuse had escaped. And then they had a fire in the main factory, and that caused further pollution, and the winds spread it around. So the claims were for property damage. Who wanted to buy property that was contaminated by radioactive material? And it was also claims for health claims of endangering the health of the people surrounding. Well, before I got there, the state of Colorado, Jefferson County Health Department, and the U.S., I don't know which, I think Department of Public Health, they did studies, and they said that the pollution wasn't sufficient to cause disease, and so the health part of it was dropped. Right at the time I got the case, the plaintiff's lawyers dropped that aspect of the case, and that left the property damage. There were something in the neighborhood of 8,000 homes and other properties that were in the sphere, the shadow of Rocky Flats, where this pollution had come. And people had gone out, technicians, and tested the air, tested the ground, tested the water, and tested some of the building materials, and found that there was radioactive pollution there. The structure of the organization was that the U.S. Department of Energy had contracted at different times with two different companies, Rockwell being one of them, and that's why it's Cook v. Rockwell, and then another company at another time, and they were manufacturing the plutonium, and they were in charge of that facility. It was a cost-plus contract, and Rocky Flats is north and west of Denver, between Denver and Boulder. So we had battles over the class, how to identify the members of the class, who they would be. Then we had battles over how do you determine the damage that's caused by pollution as compared with the fluctuations of the economy, with housing shortages and gluts on the market, etc. And so there were tremendous issues involving nuclear physics and radiation, and there were also highly complicated issues involving real estate appraisal. So many depositions. I think eventually we had a trial, and as best I recall, there were 45 expert witnesses who testified in that trial. But to get to the trial was like trying to pull teeth. Everything that we tried to get, the Rockwell would, and the other company would say, you have to go to the Department of Energy. And the plaintiff's lawyers would go to the Department of Energy, and they'd say, that's classified, we won't let you have it. And so we would have hearings, and I would have to decide those issues. And at one point, I can't recall, I either held the Department of Energy in contempt, I think I did, or I threatened to, but I think I held them in contempt for not providing the material that they could.
Did you have to review classified information in that case? Did this have other, it was discoverable?
No, I did not, not in that case. But there really wasn't that much that the plaintiffs wanted about classified information, other than volumes, I think, of how much plutonium was there. But I remember one of the experts in that case, who would ever forget this? This guy had a PhD and spent his entire life doing this. I don't even remember the name of the specialty now, but he examined critters, mice and field mice and gophers and prairie dogs would burrow into this land at Rocky Flats, and they would come out, and part of the dirt on them from burrowing would have plutonium in it. And so then they'd be out looking around at the sun or whatever these rodents do, and hawks and eagles would come by and grab them and fly 20 miles, 25 miles away and eat them, and then digest it, and the scat from the eagle or the hawk or whatever would have the radioactive material in it. And this guy could trace, according to his scientific studies, he could trace from where they found it to where it came from, and the particular identifying remarks of the plutonium molecule that was involved, so that he could testify as to the degree of pollution that existed. I can tell you this, not only was I fascinated with his testimony, but everybody, the jury, all the lawyers and spectators and court staff, we were all spellbound listening to this guy as to what he did. And you think, how can anybody spend their life doing that? But that's what he did, and he really knew his stuff. So I just can't think of the name of the specialty, but he taught at universities and things. And I always, every time I see a prairie dog, I think of that guy. But we had a trial eventually, and the trial was about, I think, 5.5 months.
A jury trial?
A jury trial. Had a wonderful jury, and we can get into that later, but that case had a significant influence on how I handle juries. But the jury was out deliberating for about 20 days, about 3 weeks, and then they came back with their verdict, and I think it was something like $750 million, and then it was appealed, and it was reversed once, and then appealed, and then affirmed, and by the time it came back again from the second appeal, the Supreme Court denied certiorari, and so the decision and the verdict withstood all of this appellate stuff, and they settled the case then, and for less than the amount that was asked for, but something, and then I just don't recall, but it was something like $350 million that they settled it for.
And this was in 2018, some
Right.
29 years after the case was filed.
Right, yeah. And then, of course, we had other problems because the class had to file claims, and we had to have a company that specializes in distributing, and all of that sort of thing took place. And in fact, I think some of it's still going on with people still trying, because people would own the house, then they'd sell it. And who is it that's entitled to the damages? And then people had those houses, and the case was so old that some of the people died, and their heirs took it. And it's a very complicated process for distributing the money. And then we had fights over the attorney's fees. So
I recall that when the case finally settled, you awarded one of the lead plaintiff's lawyers a book called Bleak House by
Yes.
Charles Dickens. What was the significance of that?
Well, Charles Dickens' Bleak House is a huge, thick book, and it's Dickens hated the legal system in England, and he wrote about this case of Jarndyce versus Jarndyce, that was so old and in the courts for so long that none of the lawyers or the judge could remember how it started or what it was about. So they just kept on coming back into court every term with more of Jarndyce versus Jarndyce, and it's a sort of it's a satire, but it is a fair comment about the law's delay. And incidentally, you know, when Hamlet is giving his to be or not to be soliloquy, he's deciding whether or not to commit suicide, and he sets up different things that might make a person want to live and others that might want to make a person commit suicide. And on the suicide side, one of the first things he mentions is the law's delay. So Dickens just does a great job in Jarndyce. So this lawyer who had been with the case from the very beginning, and he was a good lawyer, but he was also the kind of guy that in order to say something, he's sort of like me, he's loquacious, and it would take him maybe 3 times as long to say something as another lawyer would, or 4 times as long. And his briefs were sort of the same way. He's a very gifted guy, but very, very loquacious. So when the case was all over with, I just wanted him to have something. After 20 years, we were all very well acquainted with one another. And so I gave him an inscribed book of Bleak House for him to have.
You talked about...
it was a joke, basically.
It was a good joke.
Yeah.
You talked about, in the Rocky Flats case, dealing with objections to discovery on the basis of classified information. One of the more recent cases, and another very protracted matter that you handled, involved charges against 3 defendants in Colorado for terrorism-related activity.
2 defendants.
2 defendants?
2 defendants. They were from Uzbekistan. And that case took 6.5 years from the time of arrest until the time of trial for both of them.
And what were they charged with?
They were charged with one of the terrorist statutes of providing material to a terrorist organization. And the material consisted of money and one of the defendants who was trying to get over to join in jihad. The other one had been a friend of his and had given him a check of $300, but he had been encouraging him all along and participating in a conspiracy. So the 2 of them were tried, and I separated them and tried them separately. Each trial took 7 weeks, and they're both on appeal now, which kind of surprises me, because the one with the $300 check, I sentenced to time served. He'd already spent 6.5 years. And the other one, who was more culpable, I sentenced to 11 years. But by the time those cases are decided by the Court of Appeals, they will have served their sentences. So I couldn't figure out why in the world they appeal, but they have, and it's before the 10th Circuit now.
Why did it take essentially 6 years to get it to trial?
It's like trying to pull teeth with a pair of broken tweezers. The law is governed by a couple of complicating factors, and one of them is called SIPA, which is the Classified Information Protection Act. And what essentially you have in a terrorism trial is an axis, if you will, and on the one end of the axis is due process of law and a fair trial, and on the other end of the axis is state security. And where along that line do you make decisions as to what needs to be protected for state security and what needs to be disclosed for fairness and having a just trial and verdict? And there is, admittedly, I'm not editorializing about this, a recognized proclivity of the intelligence agencies of the United States to overclassify. And the presidents have talked about this, so have and people in high-ranking intelligence officials. But they have a sort of working rule that when in doubt, classify. And so if you're having a public trial and you need to disclose what's classified information, you can't do that. So the judge has to look at all of the evidence on an item-by-item, sheet-by-sheet basis and decide whether it might be helpful to the defense, the classified information. And
Do you have to have a security clearance to do that?
well, the U.S. District Judge has a top secret security clearance because he's already been investigated and certified at the time of the appointment. But anybody else, my law clerks had to have security clearance to work on the case. My secretary refused it, so she couldn't use it, so we didn't need, we never used the secretary. There's a thing called a SCAFE, which is a secured something or other area. And we have one, they're all over the United States, but there's one in the sub-basement of this courthouse. It's called a SCAFE, or a security room, and you put material in there. One of your clients, I spent a summer down there going over as well some time ago, who was represented by John Ricciolano in the Arapahoe County District Court, and he subpoenaed FBI information under the Freedom of Information Act. So I had to go through, and I was in that SCAFE at that time. I learned what it's like to be in a cell with no windows or ventilation.
So when you're required to review classified information, you have to go to the secure facility?
Well, you do, and so the Brady material is what it's called, is any information that is in the possession of the prosecution that might be favorable to the defense must be disclosed in advance of trial as part of discovery. It's called Brady material. There's a number of other cases, but that's the generic term for it. And so I'd had this previous experience down in the sub-basement with the no air conditioning, and they lock you into the room and all that. And so I finally, I just called the lawyers in on the case, and I said, I'm not doing this anymore. I said, I'm going to make my chambers a SCAFE. And so we did, but it was, they did a thorough job. They sent in a team, and they, you know, these little tiny, I don't know what they are, like microphone detectors or something. They went through all the paintings and the furniture and so forth in here, and then whenever there was to be a SCAFE, I had to close down the blinds, because there's actually intelligence gathering information that can pick up conversation from the vibration of a window and translate it so that people can find it. All kinds of spooky things involved. And
so the Department of Defense came in here and...
well, it wasn't the Department of Defense, it was the Office of OSI or DSI, or something like that. It was the FBI, and then one of their agencies came in. And so they SCAFed it out. Now in order for me to go over the material, one of the complications was it wasn't always the same person, but they had usually a young woman who would leave Washington with a briefcase, leather and canvas, that was handcuffed to her. And I'm not sure whether she had a marshal accompanying her or not, but anyway, she would come over here to these chambers, and she would make sure that everything was done, all the doors locked and so on, and then she would bring in this container, briefcase with the classified information, and I would sit at my desk and go through it, page by page by page, lots and lots of work. When I finished, or if I left to go to lunch, she would come in and take it and keep it under security. And if I saw something that was Brady material, then I couldn't give it to the defense. I noted what it was and gave it back to the prosecution, to the Assistant United States Attorney, and said, this is discoverable material. Justice Department would take that material back, as they took all the security, but they would take that back to Washington, and I don't know the mechanics of it because it was never disclosed to me, but they have people there who would decide whether to declassify that particular document or not. And they would say, well, we think it's still classified and it shouldn't be disclosed, and I'd say, case is over, thank you very much. And so they always manage to declassify. A couple of times, and under the statute, this is permissible, is that they can paraphrase. They can take out, redact certain things that are in the classified document. Now, what I learned in this 6.5 years is that it wasn't the substantive information couldn't have amounted to more than 5% of what they were protecting. They were protecting the means, and there's another phrase they use.
Method and means.
Method and means of gathering this information. Now, if you have an iPhone and you want to call me and we're sitting 6 feet apart, that message could bounce up to a satellite and over to another one above Pakistan and down to Australia and then back over here before it even hits me. It goes into the cloud and then comes back out. So they have means of extracting this information, and it's highly classified as to how they do it. So they didn't want the means and methods disclosed, and they would, in some instances, would come back with this information. Now, I think when I look back on it, and I'm trying to change this, working with the Federal Judicial Center, but the way that the law works now is that the Department of Justice decides whether defense counsel can receive top security clearances in order to keep the judge from this impossible position and go through the material themselves. But what they did in this case, when I got it, was they said, and again, this was a case I took from another judge, but when I got it, the Department of Justice said it's not necessary in this case to get security clearances for counsel. So it was up to me. I think the law should be changed. I think the judge should make that decision at any time. And if counsel needs to receive top security clearance, in death penalty cases we have what's called a death penalty panel, and those are defense attorneys that have additional training and experience in handling capital cases. And so if we have a capital case, they come from that list. And I think that what we need in this country is a terrorism panel where potential court-appointed defense attorneys are going to have security clearances and have the experience and training necessary, because these are very special cases. In addition to the Classified Information Protection Act, there's also another act and a court that's called the SCAFE, and they issue, FISA.
FISA, of course.
FISA.
F-I-S-A.
And the Foreign Intelligence Security Act, FISA, has been amended, and when law enforcement wants, the intelligence agencies want to get a warrant, they can go to the FISA court, and it sits in Washington, and it's a secret proceeding, and the judges issue orders, but they don't disclose any of the information that's there in order to get a warrant. It's very complicated, but basically it's this. If a U.S. citizen is overseas or a U.S. citizen in the United States, and in addition, a resident alien, somebody who's legally in the United States. So you have those three categories, and they are entitled to protection of the Fourth Amendment against unreasonable searches and seizures. So they need a warrant, but they don't want to disclose any of the information. So they go to the FISA court, and under the Foreign Intelligence Security Act and its amendment, they can get a warrant. The big issue, to get back to that axis, the big issue in there is, when does intelligence gathering focus on somebody that's protected, the U.S. citizen or the resident alien? Because at that point, you have to have a warrant. So they're doing surveillance, and somebody's name can pop up, yours, mine, anybody, and we're not subject to the investigation. But at some point, you become a suspect. And then that's when the warrant has to happen. The Supreme Court hasn't decided that issue, and I decided it as a matter of first impression. I think there are other courts, district courts around the country that have too, but that's going to go to the Supreme Court as to what test you use to make that determination as to when a warrant is required. Naturally, the intelligence agencies want it to be as close, as closely held information as possible, and defense attorneys want as broad a thing as possible. And where do you draw the line? What does the judge do? And so I wrote an opinion on that, which is classified, and I had to give a redacted copy to defense counsel. Another thing about the case that is interesting is that the case started out with two defendants, and the primary defendant was at the airport in Chicago with money and various iPhones and satellite phones and things in his possession, ready to get on a plane to go to Ankara, Turkey, when he was arrested. And that's why they had to arrest him, otherwise he was leaving and going to joining the jihad. But that meant that the guy in Philadelphia, who was the co-defendant, likewise had to be picked up, because he would know that his buddy was arrested. So the intelligence people had wanted to keep this investigation going to get more contacts and to see how pervasive this particular terroristic endeavor was for Uzbeks trying to engage in jihad. And there had been activity in Germany and in Turkey, and I'll get to that in just a second. But I want to get back to this point that the attorneys, when they started out, the number one guy was represented by deputy federal public defenders. So there's no cost to the courts. The public defender has a separate budget, and they have very experienced people. And so they had three lawyers from the public defender's office that were representing this defendant. Well, because they represent him, there's a possibility of a conflict. The court had to appoint two other lawyers to represent the defendant from Philadelphia. And so we did, and the case was going along in progress until two of the public defenders left and went into private practice. So I had to then decide, well, do they send in new public defenders? Well, after 3 or 4 years, these people have a college education on this case, and to have somebody start all over again doesn't make any sense. So under the Criminal Justice Act, I appointed these two former federal public defenders to continue in the case. So then we had 5 lawyers, and 4 of them were under the Criminal Justice Act, and 1 was still with the federal public defender. So they never did get the security clearance, and I had to handle all of that declassification stuff alone. And in the meantime, we had a lot of legal research that had to be done, so I had to have my law clerk with a class security clearance in order to help me on that. It was quite a problem.
How did you deal with giving the jury Brady information that is classified?
I never did. All the information that was Brady was declassified, so that problem didn't arise. But this is the one of the big problems that we had in the case was that when you get into the Central Asia, Uzbekistan, people don't speak one language. You just don't have somebody that says, I only speak Uzbek, because there are about 3 dialects. Tashkent and the other main cities identify dialects of Uzbek. But in addition, some of them speak Kyrgyz with neighboring Kyrgyzstan. Some speak Tajik from neighboring Tajikistan. They all speak some degree of Russian because they were part of the Soviet Union and the schools were all taught in Russian and the public language was Russian. Then because they're Islamic, they also had contact with Turkey, and there are a number of immigrants from Turkey and Uzbekistan living in Germany. And then on top of that, from the declassified information, there were communications with the jihadists in Syria and also in Pakistan. So you had Uzbek, Kyrgyz, Tajik, Russian, Turkish, German, Arabic, and Urdu, and English. So there were 9 languages that were being used, and it was a Tower of Babel. When we had hearings and when we had the trial, we almost always had 3 interpreters for the defense. The defendants were not capable of understanding all this stuff in English, so we had to translate for them. And then you had all the documents that required translation, and so on. So the mechanics and the complexities of translation took up an enormous amount of time. And we had fortunately, a woman working in the court named Donnie Bush who was in charge of interpreters, and I don't know how she did it, but she could find people who could get a top security clearance who spoke Urdu, Tajik, and Kyrgyz. Tried to do that sometime. It's not an easy, but she was able to do it. But it took a long time.
You mentioned that you've developed some jury practices that you used in Rocky Flats and
and I used them in this case too.
Yeah, could you describe what unique jury practices that you've developed and follow?
I do this in all cases now, by the way, but that's where it started, was with Rocky Flats. And you have a case that's going to go on for months. So how do you find, first of all, people in the jury panel that can spend that kind of time and not be, 12 homeless people that you're giving us a new job to? How do you find people that can do that? That's a very difficult job. So we had a special veneer, that is a summonsing of jurors from the voter registration lists and the property and automobile license, et cetera, and they're all put together. And then we went through there and we culled to get this jury panel. And then we sent out to the jury panel questionnaires. And those that had hardships, those that said we couldn't possibly spend a lot of time, somebody would be, I'm a single mother with 3 children, I barely earn enough living, I can't do it. You'd have somebody that would be from the border of Nebraska with a farm and say, I can't spend that time. So I'd have to go through each and every one of these summonses and the response to see who was excused for cause. That reduced the panel down to a more workable number, and then we went through that and we drew names, and we sent to those that we draw names to that they had to report at a certain time, and they came in, and we had, and my law clerk and I primarily did this. We got some help from the lawyers on it, but lawyers are not really a whole lot of help in trying to find an unbiased jury. They tend to look for the most biased ones they could find. But we got some help from them. At any rate, there was about a eight-page questionnaire, and it had a lot of questions in it that you can see in regular trials. Where do you live? How long have you lived there? How many children do you have? How much schooling, etc. We did all that, but I consulted with a psychologist to ask questions that would elicit more verbal answers than yes or no. It wasn't a fill-in-the-blanks kind of thing, because we wanted to get expression from people of what their reactions were and get them in the habit of talking about what they think rather than clamming up and just saying yes, no, answer above kind of thing. So we did that, and they had to fill out the questionnaires, and then we made copies. We gave them to counsel, and the attorneys, I think this was all done on a Thursday, and they had Friday, Saturday, and Sunday to go over them, and then the jury panel came back again, and there were a few that were excused for cause after what they had said in their answers to this questionnaire. But then we drew names to come to the courtroom, and we figured out the number of people, the number of total number of peremptory challenges, and a couple more for hardship challenges, and then we put those people in the jury, in the courtroom. And before they were sworn in, I had already completed my jury instructions. So I recited to them about half of the jury instructions, what the case was about, the statement of the case, what the jury's responsibilities are, what evidence is, what circumstantial evidence is, what credibility is, etc. And then we drew names, and we went through a voir dire exam, and I conducted a voir dire. My main purpose was twofold. One was you have to recognize that jurors, this is not their native environment. They're not accustomed to being in court the way judges and lawyers are. So I wanted them to relax as much as possible. And so I was very conversational with them. Did not say, state your name and that. I'd say, let's get acquainted. And I would tell them a little bit about me. And, I'm a Bronco fan, and that would get people talking about different things and so on. And then the other purpose I had, and still do, is to get the jurors to understand, especially with these iPhones and other gadgets that people have, that they have to leave those out and decide the case solely on what happens in the courtroom, and decide the case solely on the law, whether they like the law or not. And so that takes some time to get people to appreciate that and tell them why all these precautions are being taken. And so when I finish that, then I turn over the voir dire to the lawyers, and most of it's in the questionnaire, so they don't have to go through and what isn't in the questionnaire, they've talked about themselves.
But you let lawyers do some questioning of jurors?
Well, yeah, they do. They question them, and the only restriction I have is they can't ask whether they agree with the law or not, because that is something they're going to follow whether they like it or not. And I also explained to them, if they don't like the law, they can write their congressman about it and change it, but right now we're going to use this. And I try to explain it in a way that they understand. For instance, an example I use all the time is that if you have a parent with young children, I say, your kids are out in the yard, and one of them comes screaming and crying, the other one did something, you just don't go out and whack that other kid. You try to find out what happened. And you just don't do it on the accusations that are made when somebody wasn't even present to hear it. I said, that's what a courtroom is like. We want the witness here. And we don't want people trying to decide it on other issues. And I give them a couple of horrible examples that I've had before I started doing this, of people using their iPhones and what have you to readjust the evidence that they've heard. And so I do that, but then the lawyers can get up and they can ask them questions. Well, you know, it says you already said you've traveled in certain countries. What did you think of Russia when you visited there? Or what was your thoughts when you were in India? And they will ask questions to get more information from them. They'll have children, and children, some of them gone to college. And did you notice any difference between them when they came home? And they'll ask questions to get them to talk more. And once the voir dire's done, and we've got the jury, at that point, I give the jurors copies of the instructions. We have settled them in the final trial prep conference about 2 weeks before.
Yeah, copies of all the jury instructions?
The total set of jury instructions.
You do that at the beginning of the trial?
I do that as soon as the jury's sworn in. And the next thing I do is they also receive clipboards with writing materials, with pen and paper. And I tell them if they have any question, write it down, and at the break, give it to the courtroom deputy, and she will make copies, and I'll give them to counsel and me, and we'll figure out what the answer is. Or if I can't answer it, I'll be able to tell them why I can't and explain it to them. And so when the recess is over, we bring the jury in, I read the question, verify that's what they said, and then I give the answer that we've made a record on. The other thing that happens is that once I read these instructions at the beginning, then the lawyers make their opening statements, and they can use the instructions and the forms of verdict and include them in their opening statements. As an example, they could say, you know, we have to prove X, Y, Z. We're going to call witness Jones. He's going to testify to X. We're going to call witness Brown. He's going to testify to Z, and et cetera. So they can explain it to the jury. And the jury's sitting there looking at the instructions and what the elements are that have to be proved and so on. So they're hearing it for the second time, because I've gone through it. They're also seeing it. And I've consulted with educational psychologists that tell me people never really learn anything the first time you say something. It's the rule of threes. You have to tell somebody what you're going to tell them, then you tell them, and then thirdly, you tell them what it is that you've told them. And so that's what, that's sort of the standard I'm trying to set. So we go through these instructions, the attorneys go through them, and then during the trial, an attorney can just stop at any given time and say, Judge, I'm switching subjects. I'm going from the substantive offense to, well, in a civil case, to damages. Or they could say, I'm going from, in a criminal case, from count 1 to count 2, and there are different elements in it. Would you please read the instruction on conspiracy? Or would you, if it's a civil case, I'm going from liability to damages, would you please read the instructions on damages? And I will stop the proceedings, tell them what the numbers are, they get out their copies and they read it through while I go over it with them. And I always ask them, do you understand that? Sometimes somebody will say, well, I don't quite understand what does this mean, and I explain it to them. And what I'm trying to do is to make it an integral part of the trial, the instructions, so that the instructions, popular word is bond. I want the jury to bond with one another. I want them to bond with the instructions as well. So we do that. And then at the end of the case, when all the testimony is in, that's the traditional time at which lawyers and judges declare a recess, tell the jury it's none of their business. They go back into chambers and they play 52-card pickup with a lot of stock instructions, and the judge puts them together, and they make a record, and then they go out, and most of the time, the jury doesn't get copies of it to read as long as they're going along. And then the judge gives them, and I've sat as a juror, some of them are careful, others just mumble it, and that's the end of the instructions. And then in the federal system, the lawyers are supposed to make their closing arguments before the instructions. So that's because the judge allegedly doesn't know what the instructions are going to be until he hears everything. So then the instructions are going to be done. Well, there's studies that show that the greatest dissatisfaction people have with jury service is delay, sitting around doing nothing and waiting. And of those delays, the one they dislike the most is when all the testimony is in and they have to wait until they get the closing arguments and the instructions. So I've reduced that to an absolute minimum, and we declare a recess. Everybody goes to the water closet and comes back, and the attorneys, I always ask, do you have any other changes to the instructions, any additions or subtractions, and then bring the jury in. And so I'm trying to cut down on that delay so the jury's still interested. Then we have the closings, and then finally I get out the instructions and go over again. These are the instructions, and they take them with them to the jury room. So that's something I learned, especially in a prolonged trial. The other thing, in cases that last for longer than 2 weeks, 1 week trial, you don't need to do this, but what I will usually do is try a case in Monday, Tuesday, Wednesday, and Thursday, and then on Friday, the jury comes in the morning, and the lawyers make mini summations, M-I-N-I, summations, and say, this is what we did this week, and this is what we're going to do next week. And so they tend to sum it up and then give a forecast of what, then they come back Monday, Tuesday, Wednesday, Thursday, and Friday they get to do the same thing. And if you've got a trial that lasts for more than a month, as the Cook v. Rockwell was 5.5 months, and I talked to the jurors afterwards, they said they couldn't have gotten through without those many closings to help them to put things into a framework. Then they go in and they deliberate, and they come back out and they reach their verdict, and I have a special instruction I again drafted with a consulting psychologist that helped to do this, about how do jurors it's called an advisory instruction. They're told they're not bound to do this, but this is what other juries have done, and you may find it helpful. How do you go about electing a presiding juror? How do you vote by voice vote or use ballots? What are the advantages and disadvantages of each? And what happens when you get to a hard spot where people aren't agreeing to something? And it's best to pass that by and go on and then come back to it later. And and also you try to encourage them never to get involved in personality conflicts, to get angry with one another, and that from time to time it's not a bad idea to resolve that they're all there for one purpose. And I'll tell you what's happened with that advisory instruction. Some judges in the state system will not use my instruction because they say it takes too long. It's about 3.5, 4 pages long. But I'll tell you what happens with it. I have yet to have a hung jury. Just don't have.
Actually, I remember one that you did have recently. It's called SEC versus Parker.
I did have that. I did have that, yeah. And I think you're right. That's the only one. And I don't think it could have been avoided. That was, I think the arrogance of government counsel caused that hung jury in that case. But it came back again, and we tried it without a hung jury and used the same instructions then. So you're right, but I did have that one.
We've been going for over 2 hours. You want to take a break?
If you want to, yeah. You want to?
Sure.
Okay.
We can take a short one, we can go to lunch, what's your pleasure?
What,
What's your pleasure, actually?